today or any first?
4 or 5 first.
Okay. It's today, 20th. Do you recommend a grant in this?
I'm sorry.
You recommend a grant?
Yeah.
All right. Yep. Good morning. Everyone there in the jail?
We're ready to go, Your Honor.
All right, thank you so much. I'm Judge First. It is my duty this morning to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the constitutions of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. You have the right to know and understand the charges placed against you. You have the right to a speedy trial. You have the right to a trial by jury, or you may waive or give up that right and have your case tried by a judge without a jury. At trial, the state of Ohio carries the burden of proving your guilt by evidence beyond a reasonable doubt. You have the right to meet your accusers face-to-face and to cross-examine the witnesses for the prosecution. You have the right to summon or subpoena witnesses on your behalf, and you may not be forced or compelled to testify against yourself. You have the right to counsel. If you're unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. However, you will not be denied an attorney if you're unable to pay the fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have the right to a reasonable continuance to hire one. Now this morning, you're not here for the trial of your case. You are here for an arraignment, or you may be here for a first appearance. At the arraignment, it's your opportunity to be informed about the charges placed against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statements you do may be used against you. As your name is called, you'll step forward. You'll be asked when you received a copy of your indictment, or you may be charged by way of information, and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it's been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive or give up that right, 24-hour notice, and will complete your arraignment this morning. If your case is proceeding by way of information, I will ask your attorney to place on the record that they discussed with you waiving the presentment of your case to the grand jury. You'll be asked if you know and understand the charges placed against you. If you knowingly and willingly sign the waiver, if you consent that the charges proceed by information instead of indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice and reading of the information. Finally, you will be asked how you plead. A defendant may plead not guilty by reason of insanity, guilty, or with the consent of the court, no contest. If you wish to plead guilty and you do not have a lawyer, the court will assign counsel for you so you may have a full understanding of your constitutional rights and the evidence being produced against you. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you've been charged with a crime of violence and or any drug offense, under Ohio law, you cannot knowingly have, carry, or use a firearm or dangerous weapon until your case is concluded and you hear otherwise. This case is being under disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges. Even if you have a permit to carry a gun, you are still under disability until your case is over. Upon indictment, the sheriff who issued the permit shall suspend it until your case is over. If you're over 18 and have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. If you're placed on a GPS or electronic monitor or a transdermal alcohol device as a condition of your bond, you will be required to follow all the rules and conditions of GPS electronic monitoring. Specifically, any unapproved leave, late return, or being in an unauthorized location may result in a warrantless arrest. Failing to properly charge or not charging your unit may result in your warrantless arrest. Tampering with or otherwise damaging your unit may result in your warrantless arrest. You understand that you may be arrested without a warrant if you violate any bond condition or rule of GPS electronic monitoring. You must sign the GPS electronic monitoring rules, which will be explained to you prior to your release as a condition of bond. When GPS electronic monitoring is ordered as a condition of your bond, you will be asked by the judge, by me, if you were listening to the instructions, if you understand that the rules allow you to be arrested without a warrant if you violate the terms, and if you understand that you must knowingly, voluntarily, and willingly sign these rules prior to your release. Finally, pursuant to Revised Code 293799, if you do not appear in court as ordered after being released on bond, you may be charged with a felony of the 4th degree. Inmates in the county jail have the right to be present in the courtroom. Do any of them wish to be in the courtroom, or can we proceed?
You can proceed, we're all fingers around.
All right, very good.
We'll start in the courtroom, case number 695-654, Morgan Malone.
Good morning, counsel.
Craig Sibby on behalf of Justice Hoscom.
All right, you wish to enter your plea?
We wish to enter a not guilty plea judgment.
All right. Waive the reading and notice?
Waive.
All right. Defendant court with retained counsel, reading of the indictment, 24-hour service waive, plead not guilty is entered, original bond continued, $5,000 at 10% or cash. No contact with the victim, do you understand? Yeah, you have to speak, all right. And you'll be with court supervised release and GPS exclusion inclusion. The judge assigned is Peter Corrigan, your first pretrial, November 6th at 9 a.m.
Thank you.
Okay.
Case number 693-553, Jack Costas.
Good morning, Your Honor. Kevin Spells here on behalf of Costas. Judge, you've had the indictment in excess of 24 hours. Waive reading and plea not guilty.
All right. Defendant in court with retained counsel, reading of the indictment, 24-hour service waive, plead not guilty is entered. Original bond continued, $5,000 at 10% cash. The judge assigned is Jennifer O'Donnell, first pretrial, November 6th at 9 a.m.
Thanks so much.
Good day. Good to see you, Mr. Spelzy.
You as well, Your Honor.
Next to jail, 9 South, 696-264, George McDonald.
Good
Good
morning,
morning,
Your Honor.
Mr. Nicholson. Is he in jail?
Yes, jail.
Oh, there he is. Okay.
Good morning, Your Honor.
Good morning.
Antonio Nicholson, 0091858, on behalf of Mr. McDonald, Your Honor. Mr. McDonald has received a copy of his indictment. He'll waive the reading of such, as well as a 24-hour notice, defects in service, and respectfully enter a plea of not guilty, and ask that the recommendation of the bond commissioner, Your Honor, be adopted. Thank you.
All right, defendant in court with retained counsel, reading of the indictment, 24-hour service waived, plead not guilty is entered, bond set $25,000 cash, surety property, or 10%, with court supervised release and GPS home detention. The judge assigned is Kathleen Satula, first pretrial, November 8th at 9 a.m.
Thank you, Your
Good
Honor.
day.
Have a great day.
Is that it? You need a minute?